Kaylee said, I'm Karen Starbowski. I am with Mass Mutual. I am a financial planner, but I primarily work in the special needs community. I have a designation called the Chartered Special Needs Consultant, and that allows me to work with families who have children with special needs. Today, we are going to be talking about how to create a life care plan. Oops, sorry. This is my disclosure side. I need to let all of you know that I am not an attorney nor a tax preparer, so I cannot give tax or legal advice. And I do hold a securities license. Today, we're going to talk about what is a life care plan, the timeline, some common misconceptions, some planning steps, what a letter of intent is, how to get it started, and the importance of integrated planning. As Kaylee said, I'll take questions as we go along. I will keep an eye on the clock, though. If we get too close to the end, I want to be conscientious of everybody's time. So I'll hold off questions to the end just in case. But go ahead and ask them as we go through, unless we start running short for time. So what is a life care plan? A life care plan is a plan for your loved one with special needs that ensures that the assets and resources are there for your child when you're no longer here. So what does that mean? It means that we're creating a plan that if something happened to you tomorrow, somebody would be able to take over for you. And I know it's not the same as you as a parent or guardian, but that person wouldn't have to start from scratch. They would know how to care for your loved one, what your loved one prefers, and would have the finances to do so. I'm going to go over the whys too. Why your dependent needs one. Your loved one needs one because for a couple of reasons. One, if you're not here, we want to make sure your loved one with special needs, someone has the guidance and the wherewithal to take care of them. The other reason we're creating a life care plan is because if your child is on government benefits, they cannot inherit more than $2,000 or they'll be thrown off their government benefits. So creating a life care plans allows them to inherit and not jeopardize their government benefits. So some common misconceptions that it's not affordable. Someone will help financially. I'm not sure who that someone will. Trust accounts are only for the wealthy. We're going to go over that. And I already mentioned that, your child can't inherit directly more than $2,000 or it will impact their government benefits. All will be taken care of in a will. Some things can be taken care of in a will, but not all. And the one that I still see is other siblings will provide care. Well, they might provide the care, but disinheriting your loved one with special needs and giving all the inheritance to one of the other siblings is not wise either. It's not wise because your other child may get in a car accident and get sued, and there goes all the inheritance. Your other child may get married and divorced. There goes the inheritance. Your other child may become financially irresponsible and have to file bankruptcy. There goes the rest of the assets. Or your child might just say, I don't want to do this anymore and take the money and run. And I have seen it all. So that's not a proper way to plan. So these are the basic 10 steps for creating a life care plan. There's always a primary issue with a parent or guardian, why they're ready to do this. So we address those concerns right away. And then we help create a planned vision for the future. So what will entail, and we'll go through these details as we go through the presentation. It's also about determining if guardianship is needed, identifying all the financial resources, preparing life care plan costs or forecasting those life care plan costs, preparing a letter of intent, preparing legal instruments, um, having a special needs trust and or an ABLE account, holding family meetings, and reviewing annually. And we'll go through all these steps as we go through the presentation. So the timeline. So I don't know, since we're live, but we're not live. I don't know how old your kiddos are. But before the age of 18, things are done one way, and after the age of 18, things are done another way. So for those of that you have littles, you probably have all techs, you're probably getting services. If your kids are a little bit older, you're looking at transition planning because trying to decide when your child will leave the school systems, whether it's at 18 or at 22. But at 18, the government considers your child an adult regardless of their abilities. So at age 18, we're going to apply for SSI based on what your child has. And that's when that $2,000 comes into play, where your child can't have more than $2,000 to their name to make sure that they qualify for SSI. You're going to make some decisions to determine if guardianship is needed or the different alternatives. Go through get the legal structure set up and decide on next steps for your child. And we'll go through those too. So a letter of intent. A letter of intent is probably one of the most important parts of creating a life care plan. As it says here, it's not a legal document, but it's super important. What a letter of intent does is it provides all the details about your loved one with special needs. So think about your day-to-day. For those of you, you see your child every day, you interact. Think of all the things that you know that someone else wouldn't know if you weren't here. That's what's captured in a letter of intent. It can be as simple and straightforward as doctors, meds, therapists, but then it's going to get into favorite colors, triggers, their favorite activities, their favorite people, their favorite food. They need to brush their teeth with warm water, whatever it may be, so that if somebody picks up this document, they won't have to start from scratch to help take care of your son or daughter. It can also contain future wishes. So, where would you like your child to live? What social activities would you like your child to maintain if you're not here? All of that is covered in a letter of intent. The first time is the most challenging. We have templates for you, but of course, the first time is the most challenging. But what I recommend is after you complete it, put that date in the calendar as a reoccurring event so that next year on that date, you can read it and see if there needs to be any updates. The other thing that I have to remind parents of is you need to print it off because somebody's got to be able to find this if you're not here. Usually recommend keeping it with your estate planning documents. Super important part of creating a life care plan. So how do you get started? So we get started by doing your planning for your household first, because if the foundation isn't there with your financials, how are we going to plan for your child? Sometimes we call this retirement times two, because our children can live 20 to 30 years past the parents. I have a cousin who's 69 with Down syndrome, and she still lives in an apartment by herself. So never, when she was little, who knew that she would be able to do that? But she's had a fantastic life, and my aunt passed away probably 15 years ago. So this is, why we want to make sure all your finances are in order and there are enough assets for 20 to 30 years past you. So then we get into the vision and what's next for your loved one. So residential. Many parents will have their children live with them as long as they can, and there's nothing wrong with that. but we want to make sure that there are plans for if you're not here. Is it with another family member? Is it with at another residential place, whether it's a group home or a place like Rainbow Acres or a place like Treasure House? What fits best with your family? There's no wrong answers. There just needs to be an answer. What is the next step when you're not here? Is it another sibling? Is it another family member? The one thing that I do recommend, though, when it comes to the residential is no matter how old your child is, start looking now. Get an idea of what fits best for your family and what fits best for your loved one with special needs so that you can put it into your plan. So if something does happen, people have an idea of what you would prefer. As far as education goes, I know there's been some challenges, but law says your child can stay in school until age 22. Um, and that's totally up to the family. It's up to the individual. It's up to whether they're receiving a benefit from staying in school so long. And then what are next steps? Is there some additional schooling or training or employment training next for your loved one? The goal of this plan is to create a well-rounded plan for your loved one. We don't want anybody sitting at home on the couch. We want them to continue to enjoy what they want to do and feel fulfilled and feel like they have a purpose, whether that's a paying job, a non-paying job, a volunteer job, whatever it may be. We also want them to have a social life and recreation. So keep all of that in mind when you're thinking about creating a life care plan for your loved one. I feel like I'm talking really fast, so if anybody has any questions, please feel welcome to interrupt or put in the chat if you have questions. So identifying those financial resources. So we want to make sure that, you as the parents have what you need now and during retirement. We want to, you might have a person in mind who will be with your loved one when you're not here, but do they know that? So we want to make sure that's communicated and, your wishes and desires for your loved one with special needs. We do a deep dive into your employer benefits. I find many times that people are paying for things that they don't use, or they don't really know what they are, or they don't realize how much they're paying when you multiply it by 2 and then by 12 to fill out the year, that they're actually overpaying for a benefit and we can get it cheaper somewhere else. We look at retirement plans to anticipate what you're going to get in the future, whether it be a pension or your 401k, how much you're contributing to your 401k. Could you contribute more, less? Is it the right amount? How is it invested? Is it fitting your risk tolerance? Um, are you getting life insurance through the employer benefits? How much? Are you overpaying? Are you underpaying? Can you get more? So it's really important. I do a lot of employer benefit reviews in the October, November timeframe because that seems to be when all the companies renew their benefit plans. Excuse me. So we also want to make sure you're getting all the government benefits that your family and your child qualifies for. So most families don't qualify for SSI before your child turns 18 because the resources are based on what the parents have. And with that $2,000 limit, it doesn't take much for a parent to not qualify for SSI. Their child doesn't qualify for SSI under the age of 18. But is it after the age of 18, excuse me, like I mentioned earlier, your child will qualify on their own. So we want to make sure there are not any accounts in your child's name that have more than $2,000 in them. And I want to stress too, what happens next with SSI. So SSI right now is nine, I should know this, 67 a month, which we all know a person can't live on. That's not a sustainable income. But let's look at the benefits around SSI. So if your child, gets registered for SSI at age 18, what that means is when you or your spouse retires, they qualify for disabled adult child benefit. And that means they're going to get a raise calculated based on 50% of your retirement income, your Social Security income. So if you or your spouse file for Social Security benefits, and we're just going to do easy math, you were getting $3,000 a month, then your child would get a raise up to $1,500 a month. So that's a little bit more. So when we're planning assets for the future for 20 to 30 years, that's 1,500 times 12 times 20 to 30 years is a lot of money that we don't have to plan for. And then when the parent passes away, the child gets an additional raise up to 75%. So again, those are assets we don't have to plan for. And the one thing that I forgot, when your child originally switches from SSI to disabled adult child benefit, 2 years after that date, your child then qualifies for Medicare, no matter how old your child is. So that's a huge benefit to have those good insurance benefits. So legal planning, and that is part of this. There's a whole slide on trust, so I'm not going to cover it here on this slide. Guardianship. So there's no right or wrong answer when it comes to guardianship. In Arizona, we have three choices. We have full guardianship.
Here,
And
we have a question in the chat as well. I don't mean to interrupt, but we have a question in the chat.
okay, let me go through this slide and then I'll come back to it, okay? So guardianship, you have full guardianship, or then you have some carve out options. You then have supportive decision making, which is fairly new in the state of Arizona. And then you have powers of attorney. So powers of attorney are the simplest. It's not a court procedure. Powers of attorney, as you may know, you can get the forms or have the lawyer generate forms, and everybody signs them, and there's powers of attorney for your financial powers of attorney and medical powers of attorney to assist your child. The downfall of them is if your child can be manipulated, easily influenced. Somebody could take them to a bank with new documents and have them sign them, and then they'd have financial control. So depending on your child, that may or may not be a good way to go. Supportive decision making is the next level up. Supportive decision making is a contractual arrangement where you help your child pick a team that help him or her make decisions in their lifetime. Like I said, it's fairly new. We're still trying to get our arms around it. But it may be a good alternative for your child if you're very comfortable in how they make decisions. And then there's guardianship, which is a court process. Most people hire an attorney, but I do know some people that do it on their own. And you can have carve-outs if you wish your child to vote, to drive, or to get married. So we have choices now, and I think that's what's important when it comes to guardianship and all the alternatives is we have choices. Choices so you can decide what best fits your family. And go ahead, what was that question?
Hi, can you hear me?
I can.
Hi, I just wondered about the in-kind support deduction with Social Security.
Okay.
And So when they've already made a decision and they've granted that minus the in-kind support deduction, what is the best way to, I mean, we submitted the appeal, but it seems to just kind of be stuck in a decision-making
So you're
process.
talking
So
about the 250 or the $300 deduction
yeah,
from the
it's a
SSI?
one-third deduction. Yeah.
Right. So the way that I found, the best way I found to fix that is to create a lodging agreement.
Okay.
And we have a template for it. So you create the lodging agreement and submit that to Social Security. So the lodging agreement states that you are charging your son or daughter lodging
Mhm.
expenses to live in your home. And then they'll pay you back that you
Okay.
won't get it back pay for it, but going forward, you'll get the full amount.
And then you said there's a template somewhere on a website, or we can just look up a lodging agreement.
You can, at the end, you'll have my contact information. Feel
Okay.
welcome to email me and I'll email it to you.
Okay. Thank you.
But we use this across the country, so I think that's your best avenue. Don't call it rent, call it
Yeah.
lodging, and you should get it changed.
Okay. Okay. Thank you.
No problem. Were there any other questions?
Yeah, I had put a question in. You had mentioned when the disabled adult child can start receiving half of their parents' Social Security payment. So if there's two parents who are collecting Social Security, do they receive half of both of the payments or just
The
one?
half of the highest person.
Okay, thank you.
No problem. And it's not in addition to the SSI, it's instead of.
Okay, thank you.
No problem. Good questions, ladies. So special needs trusts. So this slide could take 2 days to present, and I'm not an attorney, so it won't take 2 days to present. But the important part is to know there are different types of special needs trusts. So the preferred trust is a third-party special needs trust. A third-party special needs trust is a pre-planned trust, so it's what you're doing now while you are alive and you're pre-planning for your child's future. A third-party special needs trust does have rules and guidelines, but they're manageable. There is no payback to the state. And any money that is directed into a third-party special needs trust was never your child's. It was yours, it was an aunt's, it was a grandmother's, and it goes directly into the special needs trust. That's a third-party special needs trust. A first-party special needs trust is oops, there was a mistake, or we want a settlement. That's when a first-party special needs trust is used. So a first-party special needs trust would be if Grandma X said in her estate planning documents, all 5 of my grandchildren get $10,000. And then that money goes directly to little Jimmy who has special needs. And you're like, oops, I should have used a bigger dollar amount, but that's more than $2,000. We need to open a first party special needs trust so that he doesn't get kicked off his benefits. The other reason for a first party special needs trust is if there's a medical or a legal settlement, because that money is your child's, because they won the money based on whatever they went through. So that would be the other reason for a first party special needs trust. First party special needs trusts are challenging to manage. There are a lot more rules and regulations, and they do have a Medicaid payback to the state upon the child's passing. So there are times when a child with special needs could have two trusts. They could have a first party because they, were involved in a settlement, and they could have a third party because that's the way their family planned. That is allowed. The trustee just has to realize that they probably want to spend down the first party special needs trust first because of the Medicaid payback. Less money that goes back to the state, the better. Because on a third-party special needs trust, you can designate a beneficiary upon your child's passing, whether it's another family member or a charitable organization like the Down Syndrome Network that you wish to leave the assets to when your child passes away. A pooled special needs trust is a trust where if you're, like I said, if your child inherits a smaller amount of money or your family has a smaller amount of money, there are nonprofits that manage pooled special needs trusts for the benefit of your child. So they're a good tool to use if there's not going to be a lot of assets, but it's more than $2,000. So it protects your child's government benefits because they, when written correctly, that the language in the document and the rules in the document are written such that they won't infringe on your child's government benefits. One thing that I do want to mention, though, when it comes to creating your documents, is to choose your attorneys wisely. And what I mean by that is any attorney is licensed to write a special needs trust, but it doesn't mean they know how. I have read more documents that were written incorrectly. And as I said in the beginning, I'm not an attorney, but when I find mistakes, then you really know there's a mistake. So we have some great firms in the Valley who work in this community on a regular basis. And I recommend using one of them because they know what they're doing. And as you all know, the special needs community has a lot of rules and regulations and laws that change on a regular basis, and you want your professionals to know those rules and regulations like the back of their hand so that they don't screw up anything that they write up for you. So that was a lot, and there's a lot more information on trust. So does anybody have any questions on trust before I move on? Okay, if you think of one later, you can ask it then. So ABLE accounts. So all through this presentation, I've said that your child cannot have more than $2,000 to their name because it will infringe on their government benefits. Well, just like everything else in the special needs community, there are exceptions to the rule, and, a different rule here that throws a twist into things. So for over 10 years now, we've had ABLE accounts. ABLE accounts allow your child to have more than $2,000 to their name. They were set up, it was one of the last bills President Obama signed before he left office. I'm going to move the page. They allow this year up to $19,000 to be contributed into an account for the benefit of your child. So there are rules, of course. Your child can only have one, cannot have more than one, cannot have more than $19,000 deposited into it in 1 year. Deposits can be made though by anybody. So if the grandma wants to make contributions or you want to make contributions, you may do so. It can be used for just about anything for the benefit of your child. So if your child needs new shoes, they need dental expenses, your child wants to go to Disneyland and the whole family's going, you could use this to pay for the child's Disneyland tickets, but not the rest of the families. So it's a very useful tool. It's not instead of a special needs trust because there is a cap of $100,000. If the account grows to more than $100,000, then your child's benefits are suspended, not shut off, suspended until you do the spend down. So this is a tool used with a special needs trust. I don't know if any of you remember before this was put in place, we would call it the stupid spend down rule. So if your child was over 18 and getting SSI and maybe they had a small job in between Social Security and their job, they would end up with, at the end of the month, $2,050 in their account. So you'd have to run around like a crazy person and spend $50 on stuff that your child didn't need because the account had to be under the $2,000. Well, now you could just throw that $50 into the Enable account and use it for a different time when your child needs something. So it's a great tool. The investments in there grow tax deferred, they come out tax free. And it works very well, it pairs very well with the special needs trust because it allows the trustee from the special needs trust to transfer money to the ABLE account to be used. We do have one in Arizona. Is one in almost every state of the country. I recommend that you shop them because they cost different, they have different benefits. So for example, Arizona's has a debit card, which is you'll find useful, but the debit card you have to preload. So that means you could load $200 on it, but if something costs $250, the card's going to get declined. I find this Arizona one useful if you're going to allow your child to use the debit card. If your child has that ability, it's great because then the child, if you have $10,000 in the account, they only have access to what's loaded onto the debit card. So I think it's a great benefit for a person with disabilities that you're, teaching them to manage money. If you as the parent are going to be the only one using this account, that could get annoying to have to preload the debit card. So I would look at another state like maybe Virginia, because you don't have to preload the debit card. So when you look at ABLE accounts, look at, the benefits, how their debit cards work, what fees are charged, and what investments are available to you. So again, ABLE accounts can be another like hour presentation on its own. So if you guys have any questions about that, please let me know. Oh, by the way, don't let a bank tell you they can set up an ABLE account. I've had a couple clients come to me and say, oh, my bank said they could set up an ABLE account. They can't. That's not such a thing. ABLE accounts can only be set up online through the state that you're choosing to open it with. That's another thing. It's not in the slide. Nope. I can give it to Kaylee. There's a couple resources for ABLE accounts, good websites, and they do comparisons of states. So I'll make sure you guys get that information. So we're just about done. But it's important to get started. Again, I don't know how old your littles are, but if your littles are 5, get started. If your littles are 25, get started. We don't know what tomorrow will bring, so we want to make sure that your child will be taken care of, whether you're here tomorrow or 30, 40 years from now. We want to make sure there's a plan in place. As I mentioned earlier, you want to make sure that you choose an attorney who has special needs experience. Many times you'll see attorneys that work in the special needs community and elder care, and that's because the rules and the laws are very similar or sometimes the same. And like I mentioned, there are some great firms in the Valley that primarily work with the special needs or the elder care community. Same with financial professionals. Like I mentioned in the beginning, my primary community that I work in is the special needs community because knowing the rules and regulations is a lot. And that's what I decided to focus on. So you just want to make sure that the people you're working with know you have a child with special needs to make sure they're not screwing anything up. That comes to mind your person who prepares your taxes too. You should let them know you have a child with special needs because there's different credits and deductions that you may be able to take advantage of. And of course, round out your team with, your medical providers and any other advocates so everybody knows what is happening. One thing that that was on one of the very first slides too, when I talked about having a family meeting. Family meetings are great, especially if you have other older kids. They're probably wondering what's going to happen when you're not here. So it doesn't mean having to share with them how much money you have, but it's letting them know you have a plan in place or having the discussion of would you be willing to take care of your brother or sister if I wasn't here? Or how much do you want to participate? There's all different combinations. Some people want to do the day-to-day. Some people don't want to do the day-to-day. Some people want to be in charge of, the management from up here or the paperwork from up here. So it's important to have those discussions with your family members so everybody's on board. Like I mentioned, here's my contact information. And I'm sure you can get it from the Down Syndrome Network folks if you can't get it now, don't have a pen and paper. Does anybody have any additional questions for me? Because I am done. Any questions about trusts or what else should be included in your plan? Well, thanks, everyone. I appreciate your time. If you do have a follow-up question, please feel welcome to email me, especially if you wanted that lodging agreement, those links to the ABLE